NASCAR said they don't want to be rushed. 2311 Racing and FRM have recently filed a lawsuit against NASCAR. Let's talk about it. What's up, everybody? I am Chase Holden, a.k.a. Garage Guy Chase. Welcome to my brand new YouTube channel. Please make sure to hit that subscribe button. Drop a like on this video, and I'm definitely going to want to see some of your comments about the latest on this story, which is really just the talk of the town. It's the talk of the world right now. It's kind of the sports world news story of 2024. If you're a racing fan, there may be some other stories out there, but this one matters more, and that's why you're here. That's why we're watching it now. We got to dig back into this story. If you watched the first video, you saw me dive into the lawsuit. We went over some of the documents and some of the things that were listed in there, as well as heard some statements from the attorney Jeffrey Kessler. So let's start with the big news. NASCAR has asked the court to deny the expedited discovery motion filed by 2311 Racing and Front Row Motorsports. And if you don't know what that means, here's a quick breakdown. Basically, 2311 and FRM wanted quick access to documents about the 2025 charter agreements and NASCAR's decision-making process. These teams are looking for any files that might shed light on why NASCAR moved from negotiating with this group of teams to those one-on-one deals, and why they presented a take-it-or-leave-it deal for the 2025 charters. NASCAR claims this motion is one-sided, non-reciprocal, and more like a motion to compel, calling the lawsuit baseless and meritless, as we said before. They argue that 2311 and FRM are just using the discovery process as a weapon to get more favorable contract terms. So let's dig into NASCAR's key points in their filing. The four arguments are as follows. Number one, the plaintiffs fail to show they're facing irreparable harm. Number two, the requests are not narrowly tailored to the specific issue of the preliminary injunction. Number three, there's no risk that any documents will be destroyed. And number four, the timing and procedural posture don't support expedited discovery. So basically, NASCAR is saying that 2311 and FRM don't actually need these documents right now. And even if they do, this request is too broad and isn't really about the injunction. NASCAR also emphasizes that they've already planned for a 2025 season without 2311 and Front Row having charters. They've made it clear that the deadline for signing the 2025 charter agreements has long passed, and they've already moved forward with plans for a 32 chartered season next year. Now, NASCAR might come back and say, hey, 2311 and Front Row chose to race without charters, and technically that is true. But here's the thing. Just because they made that choice doesn't mean the whole system isn't unfair. NASCAR is set up so that if you don't accept the charter, you're competing at a serious disadvantage. Without a charter, teams don't have guaranteed entry into every race, which could impact their sponsorship deals and overall financial stability. Bob Jenkins of Front Row Motorsports even said at some point the losses may become so severe that we simply cannot continue. So yeah, they're racing, but without the same financial security, guaranteed entry, or even the ability to compete on a level playing field with the other charter teams. 2311 and FRM need to prove the system itself left them with no real choice but to reject the charters under those terms. NASCAR has until October 23rd, which is next week, to respond to the preliminary injunction motion, and the hearing is now scheduled for November the 4th. That's when we'll get a clearer idea of whether 2311 and Front Row can force NASCAR to grant them charters for 2025. Now, I'm not a lawyer, but I've done my research, and I just want to say that I feel like the best thing the teams can do in this situation is keep the focus, keep the thumb, keep the pressure on proving how NASCAR's actions are harming competition in the sport. They need to show how racing without charters will cause serious financial harm, proving that losing the charter hurts their ability to secure sponsorships, it limits their race entries, and impacts their competitiveness. They also need to make sure the court gets access to key documents that might reveal pressure tactics used by NASCAR to secure these one-sided arguments. If they can prove NASCAR uses monopoly power to coerce teams into unfavorable terms, they'll strengthen their antitrust case. Finally, public perception matters big. Very big. Framing this right is a way to make NASCAR more competitive and fair for all the teams, and it will keep pressure on NASCAR. So that's the latest on 2311, FRM, and NASCAR going to see Judge Judy. We've got key dates coming up, plenty of legal back and forth to cover, so stay tuned for more updates. Let me know what you think in the comments. Don't forget to hit that subscribe button, maybe even hit that little notification bell. Every little thing you click matters, and I appreciate it. I'm Chase Holden, also known as Garage Guy Chase, and thanks for watching. We'll see you again soon.